Hello friends, in the series on the income tax cases, today we will discuss a case which throws light on the concept that how important it is for the assessee to update his contact details, whether it is address, PAN number and phone number in the PAN database and while filing the income tax returns. It has been seen that when the income tax returns are being filed, the address given in those returns are very old, even the address is not updated because the returns are being filed through programs. So it is the duty of the professional as well as the assessee that when they are filing the returns, they should ensure that their PAN database has the latest information, correspondence details, and at the same time the income tax returns. Now, how it can be fatal for the assessee has been discussed by the Madras High Court in the case of Saravanan versus Assistant Commissioner of Income Tax, and this case is reported in 483 ITR at page number 272, and the date of the judgment is 14th September 2023. In the present case, the assessee was a non-resident since 2012 and he was not in India since 2012. The assessee has applied for PAN number when he was employed in Bellary, Karnataka in 2009, and then when the PAN number was employed, he has given the address of the Indore initially, and then this address was changed for the Karnataka, meaning thereby that the PAN number was having the details of the Karnataka address. But the proceedings under section 148A clause B, show cause notice was issued to the address which was there in the PAN number. The assessing officer do not have any option because he was not having other details of the assessee. So he issued the notice under section 148A clause B at the address which was there in the PAN details as per rule 127 sub rule 2. Because the assessee didn't receive the notices, so consequently the order under section 148A clause D, notice under section 148 was issued to the assessee at the address which was there in the PAN number, and thereafter the assessment proceedings was also completed by issuing various notices under section 142 subsection 1 at the PAN number address, and consequently the assessment was also completed. When the assessee got to know about this assessment, the assessee was having one option that he should go to the CIT appeal, then place the additional evidences there and then follow the normal procedure. But the assessee chose to file the writ petition in the Madras High Court on the basis of principle of natural justice, that in the present case the assessee has not been given the adequate opportunity to be heard. So this matter should be remanded back to the AO. This was the plea of the assessee for fresh assessment. For this, court said that in the present case the assessing officer cannot be faulted because he has followed the rule 127 sub rule 2 and he has issued the notices at the address which was there in the PAN number. And it was the fault of the assessee not to update the PAN number. But at the same time the court said that since all the proceedings have been completed without serving or without the assessee having the knowledge of those notices and orders, so the assessee should get a second chance to cooperate with the department and participate in the assessment proceedings. So the court quashed the assessment order and remanded the matter back to the Assistant Commissioner of Income Tax for de novo adjudication of the matter. Friends, this seems to be very simple, but even in the writ petition, a lot of time, a lot of energy, a lot of resources are being utilized when the writ petition is filed. It takes generally sometimes 2 to 3 years to dispose of the writ petition. So it is very painful for the assessee that just for the non-updation of the details in the PAN details and the income tax returns, the assessee has to face this type of litigation. So the purpose for making this video is to just communicate a message that always update your contact details in the form of email address, phone number and address in your PAN details and in the income tax returns whenever they are being filed. At the end of this video, once again I am repeating the name of the case. The name of the case is Shravan Mani versus Assistant Commissioner of Income Tax, and this case is reported in 483 ITR at page number 272, and the date of the judgment is 14th September 2023. Thank you, friends.